Mr. President, I want to start by thanking my colleagues for being willing to stand up and defend innocent human life. I remember recently watching a young woman walk across one of the downtown bridges in Austin, Texas, carrying a sign. It said, "Abortion, anytime, any reason." That's what she was advocating for. I was shocked when I saw it because I thought even the most ardent advocates of abortion would not take that position, denying the humanity of this unborn child. But apparently that's what has become here 48 years after the Supreme Court first created a right to abortion out of whole cloth as a constitutional right. You look in vain in the Constitution of the United States, as well as the amendments to the Constitution, for any reference at all to abortion. What you will find, if you read the Declaration of Independence, is a familiar statement to all of us. July the 4th, 1776, the 13 states then that made up America said, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." By the way, there's no asterisk, there's no footnote that said if you are an unborn human life, that you are denied this unalienable right to life. Such noteworthy figures as Ruth Bader Ginsburg, who was probably one of the most aggressive advocates for abortion rights in the United States Supreme Court, later in life decried the fact that by the Supreme Court holding a right to abortion as a constitutional right denied the very sort of give and take and debate by which our differences are resolved in the states and at the national level. And I'd just like to point out some of the misinformation that you hear and read about Roe versus Wade. If Roe versus Wade is no longer the precedent by which abortion rights are decided, it will not mean that abortion will not be available in many, if not all, of the states. What it will mean is that it will be decided under our federal system on a state-by-state basis, according to the decisions made by elected state leadership, including the legislature. (1948) was when Richard Nixon was inaugurated for the second time as President of the United States. Suffice it to say that a lot has happened since then, a lot. And I think it's entirely appropriate that the United States Supreme Court revisit its precedents, including Roe versus Wade, decided in 1973, and decide if that precedent has stood the test of time. By the way, serving on the Judiciary Committee, we frequently have nominees for the Supreme Court of the United States come before the committee, and many of my pro-choice colleagues will say, "Do you agree, Judge or future Judge, that Roe versus Wade is the precedent of the United States Supreme Court?" And of course that is, along with Casey and the other decisions that have been decided since then. But they act as if the United States Supreme Court cannot revisit bad decisions and correct those bad decisions. To act as though Supreme Court precedent is somehow sacrosanct would still leave us with the likes of Dred Scott, which treated African Americans as less than fully human. Obviously, we fought a civil war. 600,000 Americans died. That'd be the equivalent of 3 million people today in a bloody civil war that tore our country apart. So being able to revisit those precedents, especially in light of the passage of time and over long experience, is entirely within the purview and entirely appropriate for the Supreme Court to do. Well, we've heard from my other colleagues that since Roe was decided in 1973, more than 60 million abortions have been performed in the United States. As originally was decided, Justice Blackmun wrote an opinion and established an event he called viability. Abortion was basically, the argument is by the opponents of, or the proponents of Roe, that somehow this decision by Justice Blackmun saying that abortion should be widely available pre-viability, that we should not be able to reconsider or take a look at that. The truth is, Judge Blackmun admitted this was an arbitrary standard. What does viability mean? We've heard 7 countries around the world have more permissive or equally permissive abortion laws as the United States. I frankly don't want to be in the same company as North Korea or the People's Republic of China, governed by the Communist Party. I would hope that America would aspire to something different and better and more humane, more in line with our fundamental statement about the unalienable right to life. But the fact that America's only one of 7 countries that allows elective abortions after 20 weeks, which, as I said, puts us in the same category as Communist China and North Korea, you would think that would raise a huge red flag and say something is terribly wrong here. How is it that we are in the same category as Communist North Korea, Communist China, when it comes to the value we place on unborn life? Well, unfortunately, we've seen the right to life become a partisan issue in the United States Congress. When you take a look at the pro-life legislation which has been introduced over the last years, we saw last year, for example, our Democratic colleagues filibustered legislation to outlaw elective abortions after 20 weeks, which is when science tells us that an infant can feel pain. Then they blocked a bill requiring physicians to provide life-saving care to infants who survive abortions. This is care that any other newborn baby would receive. And yet our colleagues, so concerned about the backlash among their pro-abortion constituents, blocked it, denying a child born alive after a botched abortion the same sort of care that any other newborn would be entitled to, and they blocked it. And the latest attack on unborn babies' right to life is Women's Health Protection Act. This bill would undermine state laws limiting abortion even after viability and undercut the Supreme Court's ruling that defined our current definition of viability. And what does viability mean? Even at 20 weeks, can an unborn child live without medical attention and support from their mother or medical personnel? Of course not. This is an arbitrary line drawn by the Supreme Court in 1973. And as we've heard from many of my colleagues, medicine has thankfully advanced considerably since that time. Well, even though the United States Congress seems to be stuck when it comes to the issue of abortion and respecting the right to life of unborn babies, thankfully the states have taken the issue up, which is why states like Mississippi have passed their own legislation to protect unborn babies. Pro-abortion advocates say, well, 15 weeks, which is what the Mississippi law says, that a right to abortion only for the first 15 weeks of a pregnancy, that violates constitutional rights. But it's interesting, it's no less arbitrary than this notion of viability, which suggests that a child can live, which they cannot, outside the mother's womb, even if they're 20 weeks or 24 weeks of gestational age. Interestingly, a number of states, like Massachusetts and Nevada, abortions are restricted after 24 weeks. In California, Washington, Illinois, those are among states that explicitly restrict abortions after viability. The American people clearly stand behind protection of unborn life. This summer, a poll found that 65% of Americans believe that abortion should be illegal in the second trimester. That's the second 3-month period of a 9-month pregnancy. Opposition to third trimester abortion is even stronger. 80% of Americans are opposed to a third trimester abortion. And indeed, the Supreme Court of the United States upheld a Nebraska law banning late-term abortion, which is essentially producing a delivery while the child is still alive, killing the fetus, and then completing that abortion. The Supreme Court of the United States upheld a ban on that third trimester late-term abortion, that brutal and barbaric practice that even the Supreme Court could not abide. Last June, a baby born at 21 weeks and 2 days. This last summer, that baby celebrated its first birthday. That's what's at stake here when you're dealing with more than just one person, or you are dealing with more than just one person. The question is, how do you balance and deal with the rights not only of the woman seeking the abortion, but also the unborn child? Right now, under its current jurisprudence, that unborn child is not even considered a human. America cannot be its best if we devalue lives of the most vulnerable among us. I believe that babies with heartbeats, fingerprints, and taste buds deserve some protection under the law. I'm proud of the efforts led by our colleague, Senator Langford, and others to make sure that we actually have a discussion about this issue and don't just sweep it under the rug. And we don't just let the pro-abortion lobby mischaracterize what we're talking about, as if eliminating Roe would eliminate abortions in America. It would just allow the states to do it on a state-by-state basis. But actually, Roe was a made-up right, created a constitutional right that's not even stated in the Constitution itself, and it created an arbitrary time limit in which abortions could be performed or not as a matter of constitutional rights. So I join the rest of this body in this country in awaiting the Supreme Court's ruling. I believe that it's more than appropriate for the Supreme Court to revisit its precedents that essentially disparaged and denigrated the right to life of an unborn child. Mr. President, I would yield the floor to my friend from Oklahoma.